All right, I want to bring in my guest this hour, Brian Gaither. He's a criminal defense attorney and a former prosecutor. Brian, thank you so much for being with me.
It's good to be here.
All right, so, as I stood here and I listened to the prosecution lay out the evidence that they have against the defendant, it's not clearly an impressive list, but when you start piling it on top of each other, you can almost get this sense of what else could have happened here. And that's the thing that would scare me about this case as a defense attorney.
Well, yeah, because it's a lot of choppy type evidence, as you see, and as the prosecution was bringing it all out bit by bit, it seems like if I'm defending the case, I have to be very careful about how I present my defense because I don't want to open the door to something that can possibly incriminate my client. And then, of course, with the directed verdict, it's really hard to get a judge to actually agree to a directed verdict, but that's all strategy too. So right now it's going to be interesting. It's a lot of little pieces that they can possibly attach to the defendant, and it's enough to go forward. But I don't know. It's interesting to see how everything's going to play out.
As far as listening to what their evidence is so far and having watched some of the trial, where do you think the strongest part of the prosecution's case is? As a defense attorney going in, getting ready to prepare your defense, where do you feel you need to present something to help your case along?
The strongest thing they actually have is potentially that 45 shell casing, because that's some form of direct evidence because they can actually place them in an actual location. But the thing is, this is not, as you see, a superhero. This is not Superman. You can't be in 5 different places at one time. That's why even with the directed verdict, my suggestion to the defense, and and when you're in the heat of battle, sometimes you don't really have time to do it. And plus, we know judges shoot us down all the time. You really lay out every charge and every element, and you show the judge why they didn't meet each charge instead of just doing a blanket. Like, we know that it's bad evidence. We're not just going to, just go do a blanket. Oh, they don't have A, B, C, D in this, and this is why it should be dismissed. No, you set it up. Count number 1, count number 2. This is why. Because what happens, it puts the prosecution in a very peculiar situation where they actually have to answer to each one of those charges. And even if they answer and the judge still denies it, you have something for appeal. So, like I said, the toughest evidence I've heard so far is that is the shell casing, but you still have like 7 other charges. So it's still going to be hard for them to kind of place them everywhere at once. So if you tackle that, I think the defense still has a great opportunity to have them walk.
Yeah, speaking of that, the charges here bother me. This complicity charge, it almost feels like a violation of constitutional rights of the defendant because it's kind of this charge that's a catch-all. It's like, we don't know exactly how it was done. We don't know who exactly did it, but we have a really strong feeling that he was involved in it, right? We've got means, opportunity, all these other things, but no real elements to the crime. So yet, let's bring this guy into court and take our chances. As a defense attorney, it really rubs me the wrong way.
Oh, definitely, and that's why I said it's so important. Sometimes you have to think further than just the trial at hand. You have to think about later on, because in the directed verdict, and we all drop the ball sometimes because, like I said, we're in the heat of the moment. With your directed verdict, you have to argue that particular charge, and you lay that out. And after you lay that out, you show the facts why it doesn't fit, and you start attacking that particular statute in your directed verdict, and hopefully, like I said, you're setting up for appeal, and hopefully that appeal can spark legislation and they can deem that unconstitutional. But like I said, it's easier said than done. We're on the sidelines looking at the game. We're not actually quarterbacking.
No question about it. And with this complicity charge, I mean, the main thing about it is, you would think, and hopefully the defense will really hammer this home, is that if I'm going to be complicit in something, I have to do overt acts that are complicit in whatever happened. They haven't even told this jury what really happened. They told them that these people died, and here's what they died of, and that we have some tenuous connections from the defendant to these crimes, but they haven't told them who actually did it and what overt acts by the defendant connect him to these crimes.
They have not addressed any of that. And during closing arguments, because, like I said, you already know that the directed verdict, most of the time, unless you lay it out, it rarely happens. but they're about to have a field day with closing. And if they present their case right, they can basically just tell you what happened. They have no clue. So yeah, they can really hammer this home, and it's unfortunate that we have to go through all this because they don't, they're reaching, but it is what it is. It says the law, especially when it's directed verdict, favors the prosecutor. You have to just wait and see.
Yeah, and it was certainly the right decision by the judge. There's certainly enough there
Yeah,
that you want to send this
to
to a
go
jury.
forward.
I think it would have been wrong not to do that. So I think he made the right decision there. All right, Brian, stand by. We're going to break down some of the evidence in this case coming up. We're going to have a Court TV close-up that examines the evidence in the Kentucky versus Martin triple murder trial. So keep it right where it is here on Court TV, your front row seat to justice.
The .45 casing escaped his attempt to cover everything up, and that is the linchpin. The .45 casing found right there next to that cellar door that was shot from the Glock 45 in his safe, nobody else's. His gun, his safe. And the dog tag left behind. So at the end of all this evidence that you will hear, the Commonwealth will come back before you and ask you to find the defendant guilty.
Welcome back to Court TV Live. I'm Michael Ayala. Now, in opening statements, Kentucky Commonwealth Attorney Barbara Whaley told jurors that Christian Kit Martin's .45 caliber bullet casing was a match to a casing found at the home of shooting victims Calvin and Pamela Phillips. Is this enough evidence to convict Martin? That is the focus of our Court TV close-up. Now, that .45 caliber gun that the prosecution mentioned in her opening statement was shown in court. And today, a weapons expert matched the casing found by family members at the Phillips home months after the murders, Manya, to a gun owned by Martin. Now, in other testimony today, the jury heard that the .45 caliber bullets found inside the body of Calvin Phillips were not a definitive match to Martin's gun. But the ballistics expert said that it could also not be ruled out as coming from that gun. One by one, this jury has heard from several forensic experts about pieces of evidence found at the alleged crime scenes, but very few of them make a direct tie to Martin. And remember, that dog tag belonging to Christian Martin that was found in the Phillips home, well, it was shown in court on the second day of this trial, and their son testified about how his sister found it. Now, yesterday, the DNA expert testified about what he found after swabbing the string and the tag itself. So take a listen.
I swabbed the string and took a cutting of the string and did the extraction on that. So the first result was that no human DNA was detected from item 40.1, which were swabs from the dog tag. Then the second result would be the partial DNA profile from item 40.2, which were swabs and cutting from the cotton string, is too limited for meaningful comparisons. This means there was some DNA present, but not enough to feel confident that we had enough to make a comparison to.
All right, that's right. You heard right. Martin's DNA wasn't even on his own dog tag. They could not find it, and we learned that no blood from either of the victims was found on any of Martin's clothing.
38, which were a rain jacket and a brown thermal shirt that belonged to Christian Martin.
Yes, that's correct.
And you found no blood on either of those items either?
No blood was found on either one of those items.
So as I read your report, when you analyze a piece of evidence for presence of blood, you can either find blood or you can presume blood. Is that correct?
Correct.
So will all this add up to a conviction or an acquittal? All right, I want to bring in my guest for the close-up here. I believe I still have Brian Gaither. Not sure. We've been having some technical difficulties with him, but I know that we have Court TV legal correspondent Julia Janae, who is standing by for me. All right, looks like we do have you there, Brian. All right, Julia, first things first, I want to go through a list here. I made some full screens of what I believe the evidence to be, and then I want to get your thoughts. First and foremost, he was seen in an area where the bodies were burned. Now, we heard some testimony in court about that. The .22 caliber ballistics could be a match to his gun. The shell casings found at the scene do match his gun, or at least believed to match his gun. Lives next to the victims, right? There's a time and space. Cal Phillips was going to testify against Martin. There's the motive. Cal and Pam Phillips expressed real fear of Martin. And again, he was a former Ranger, so that makes a lot of sense. We talked about this. His military dog tags found at the scene, but no DNA. And kerosene canisters were found in his home, and the odor of kerosene, there was testimony, there was odor of kerosene where the cars were burned. So right now, that's what I see as the evidence. How does that list play to you, Julia? Is there anything you'd like to add, or when you talk about what this jury is going to consider against the defendant?
So I'll add a couple of things that I think the prosecution really brought up today, even in that response to the directed verdict, that they have this hair that is it has similarities to the defendant's hair. But really, when I was listening to the forensic examiner on the stand, they said that they really could not make a definitive conclusion that it matched the defendant's hair, that it just was similar in color. It did say that there were some microscopic components, but there's been a lot of controversy over whether or not microscopic examination of hair without any DNA can be used to convict someone. So I think they're really hanging by a thread with that hair, but also this weird alarm that they say the defendant set at 1:10 in the morning, that suggests that he was getting up to go and burn these bodies, which we know happened around 2 a.m.
Yeah, from their opening statements, though, they say the linchpin of their case is that casing, Brian, and we talked about that in the last block. And one of the interesting things is that casing, you know, that's another piece of evidence that bothers me as a defense attorney. It was found 5 months after the murders, and it was found by family members of the victims, right? And when you talk about police going at a crime scene, looking through the crime scene, not finding a shell casing, it just seems really like a long shot to me.
Honestly, when we was talking about the directed verdict, I was just talking about stuff that it can have the case go forward. Now, let's talk about actual convictions. That's crazy. That's absolutely crazy. So you're telling me that trained officers that's investigating, like if it was me, I would get excited as a defense attorney because I'm about to cross. So you're telling me that trained investigators basically cannot find shell casings on the scene of the crime, and all of the family members are doing a better job at finding evidence than you have? And basically 5 months later, and all the evidence that's found has not been found by officers or investigators or detectives. It's been by family members. And there's no connection whatsoever to the actual defendant. You have something that could possibly be his gun, but I'm sorry, the shell casing is good enough for probable cause purposes, but as far as a conviction, the defense can have a field day with this one.
Yeah, no question. I think there's definitely issues that they can work with. And Julie, I think it's important to point out, and we heard some of this in the argument for the motion to dismiss, there was actually some other evidence that was in that initial probable cause hearing that the prosecution had that they weren't able to use or did not use at trial. Tell us about that.
This, in my opinion, was a major part of how they got that indictment. They found through their FBI report on the cell phone data from Kit Martin's phone, or cell towers that related to his phones, that his phone was not at home like he said he was at the time of the murders, and that his phone was at one point moving along with the victim's phone toward his place of business where he worked at Fort Campbell. So these two things were presented to the grand jury along with the ballistics, along with the motive, and ultimately there was an indictment. But the defense challenged those cell phone phone records, and the state agreed. They did not call that cell phone expert and did not even bring it up in their case in chief at all. So it seems that that was unreliable, and now we can expect that the defense is going to have a heyday bringing in their own cell phone expert to refute that and also show that he was in fact at home.
Now, Brian Gaither, this leads me to my next question. We all know prosecutors, they have a lot of power. And you have a piece of evidence that you realize is unreliable that clearly, and I agree with Julia, was probably a big part in getting the probable cause to move forward, to get the indictment to move forward with this case. You lose that evidence, but yet and still you push forward with this case with evidence that, again, is really, to me, not the strongest evidence. And my question is, prosecutors, man, why don't they just look at this and say, you know what, let's take a step back. Maybe this isn't a case we need to bring.
I always ask myself that question every time I was in a prosecution office and I handled cases. I was a public defender for 5 years and a prosecutor for 3. And I guess my experience being a public defender actually helped me be a prosecutor, because when I took an oath, the oath is to seek the truth and seek justice as a prosecutor. And if I don't have enough evidence based off the Constitution to go forward, you really should get rid of the case, because that is justice. You don't have enough. Why they do this is several reasons. Political reasons. It could be personal reasons. Sometimes, unfortunately, I'm not going to talk about the prosecution here in this case, but I'm talking about in general. Unfortunately, it could be a lack of training, because sometimes if you think one track and you're thinking like a prosecutor all the time, you can't properly evaluate a case. So in your mind, you may think you have a strong case, but you didn't poke holes in your own case to see if you have one. So.
Yeah, and
unfortunately, that's what we're working with.
That's the way of the world, you know. And I have no doubt that these prosecutors think that they have the right man, but you have to look at your evidence and say, do I have the horses to get this, to put this family, to put this person through this ordeal? All right, Brian Gaither, I want to thank you so much for being with me this evening. I truly appreciate it. Love your insights. Hopefully you'll come back and join us again. It is almost time now for our Talkback segment, where you tell us what you think. Today's question was, is the forensic evidence in Christian Martin's triple murder trial convincing enough for a guilty verdict? It's coming up next right here on Court TV.